What's up, everybody? We are back. The Commonwealth has finally responded after a motion and a supplement by the defense trying to dismiss this case, saying it's double jeopardy, saying the jury came to a verdict on charges 1 and 3. So we're going to hear what the Commonwealth thinks about what the jury did, what the Commonwealth thinks about the case law that we've already discussed at length from the defense's motion, what the Commonwealth wants to happen next, and we get a little insight into what's it going to look like? Are they going to retry this case no matter what? All those indications and facts we're going to talk about in today's video. We're going to answer your questions. Make sure you guys hit the like button if you have not already. All right, so we're going to read through the Commonwealth's motion. It's not incredibly long. It's only about 15 pages. We're going to see what we can learn from it, see what it points to, see what it just flat out says, how it could affect the potential jurors. Because let's remember, as we read this, I feel pretty confident that the jury is paying attention, that the jury is following this case in the media now, that the jury is listening, the jury is watching. And will this motion affect anything the jurors may say if we have an evidentiary hearing at some point or a jury interview? All right, the Commonwealth's opposition to defendant's post-trial motion to dismiss. Now comes the Commonwealth in opposition to the defendant's post-trial motion to dismiss her indictments for second-degree murder and leaving the scene of the accident causing death, as the defendant's motion is premised upon hearsay, conjecture, and legally inappropriate reliance as to the substance of jury deliberations. Further, contrary to the defendant's claims, throughout jury deliberations, the defendant was given a full opportunity to be heard. The jury's communications to the court explicitly indicated an impasse on all charges, and the court carefully considered alternatives before declaring a mistrial. The defendant's unsubstantiated but sensational post-trial claim that the jury reached a unanimous decision to acquit lacks any merit or legal foundation. So, with the opening paragraph to give us an indication as to what's going to come in this motion, I will tell you, and this probably will surprise some, it won't surprise others. There are points and parts of this motion I absolutely agree with the Commonwealth on. But there are other parts I absolutely don't agree with or understand how they could possibly be promoting truth and justice with some of the positions and arguments they make. So it's going to be an interesting read because there are going to be parts, like I said, that I'm like, yeah, I get it. And I kind of agree with them. And if that's all there was, I might rule in their favor. So let's take a listen and take a look. On June 9, 2022, defendant was indicted by a Norfolk grand jury for second-degree murder, manslaughter while operating under the influence, and leaving the scene of personal injury/death. A 10-week trial commenced. The jury began deliberations on June 25th. In addition to 3 indictments, the jury was instructed on 2 lesser includeds to manslaughter while operating under the influence, 1 involuntary manslaughter, and 2 motor vehicle homicide, operating under the influence of liquor and negligence. The defendant's motion states that the court's decision to declare a mistrial was sudden, brief, and unexpected. Neither preceded nor accompanied by discussion with counsel. Yet, the defendant's motion and supporting affidavits of counsel inexplicably omit the full opportunity that the defendant was given to be heard and the defendant's consent to the mistrial. Beginning on Friday, June 28th, 2024 at approximately 12:15 p.m., the jury sent a note stating, "I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict." At that time, the court requested argument from the Commonwealth and the defendant as to whether the jury had engaged in due and thorough deliberations. The Commonwealth responded that the jury had not had sufficient time to deliberate and requested that the jury be instructed to continue their deliberations. On the contrary, Attorney Yannetti argued, "We believe that there has been sufficient time," and advocated for the jury to be declared deadlocked and provide the Tui Rodriguez instruction. Attorney Yannetti stated The word exhaustive is the word I think is operative here. They're communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and they're at an impasse. You know, this is a case where the jury has the legal instructions. They've only really asked one question, which was to try and get a report they were not allowed to get. And I think the message has been received that the evidence is closed and they won't be getting anything more. They've been working essentially nonstop over the last 3 days, 4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is the jury should be read the Tui Rodriguez model instruction and go from there. I will just say, and no surprise, because this is pretty much what I said in the prior video. I agree with the Commonwealth here. I think this is how it went. I think this is what the defense wanted. I think they made their position known. I think any lawyer knew where they stood based on this position. Does this change the fact for the rest of the motion? No. But like I said, there are parts I do see where the Commonwealth is coming from with their arguments. The Tui Rodriguez instruction has a certain sting. A Tui Rodriguez instruction should not be employed prematurely. The court ruled that given the length of the trial, the number of exhibits, and complex issues in the cases, there had not been due and thorough deliberations and instructed the jury to continue deliberating. On Monday, July 1st, approximately 10:45, jurors sent another note. The judge, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The diversions in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. Following receipt of that note, the court again inquired of the Commonwealth and the defense as to whether there had been due and thorough deliberations. The Commonwealth argued that although the jury had been deliberating for almost 22 hours, given the length of the trial, the number of the witnesses, the jury had not yet had time to engage in thorough deliberations. Yannetti again sought a Tui Rodriguez instruction stating that the jury has come back twice, indicating essentially they're hopelessly deadlocked. They said they've been over all the evidence. At this time, they have the fundamental disagreements about what the evidence means. It's a matter of opinion. It's not a matter of lack of understanding. The court found that at this point, the jury had engaged in due and thorough deliberations, noting that this has been an extraordinary jury. The court indicated it had never seen a note like this reporting to be at an impasse. At approximately 11 a.m., the jury was advised of the full Tui Rodriguez instruction, including that it was the jury's duty to decide the case if you can do so conscientiously, and that there is no reason to believe another jury would be more competent to decide this case. On July 1st, at 2:30, the jury sent a final note stating, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. Following receipt of the note, the court discharged the jury and declared a mistrial. Okay. So before we get to the second part, that's kind of argument one, that the defense had their opportunity. They didn't make certain objections. They didn't make certain requests. They knew where the jury was going. They seemed okay with it. And the judge declared a mistrial. And there wasn't anything wrong at that point with the judge declaring a mistrial. I think that is a good argument. I think that is a decent argument. That is the part of the motion that I can understand where the Commonwealth is coming from. And it's where I thought kind of the weak part of the defense's argument was. Hey, Peter, when did direct contact become hearsay? So RJ, my guess is they're referencing at least partially the intermediary or informant as opposed to the jury. But again, hearsay can be admissible in certain situations. This might be one of them, and they can discuss it in an evidentiary hearing and see where we go from there. Were the verdict forms ever turned in or just the note to the judge? My guess is the verdict form was also turned in and it was probably blank. I don't know that to be a fact. Does she have to pay attorneys for a second go round? So pay for counsel twice if tried again? Yes. And that's the really crappy part and the part that is so prejudicial to the defendant, that they have to pay all this money twice. They have to go through all this again twice, which is why if you can shed two of the charges, that at least is promoting fundamental fairness and only going forward on what the jury had not prior unanimously decided. Thank you, Rebecca, for gifting 5 memberships. All right. So now let's get to the second part of their motion. The representations made in counsel's affidavits have no legal bearing on the mistrial, as the jury did not reach any verdicts, partial or otherwise. So this is interesting that they say it has no bearing. So statements directly by jurors have no bearing on anything in this case. Find that hard to believe, but that's what they say. They're coming out swinging. Verdicts must be reported in open court. Generally, sure, that's true. The only verdict which can be received and regarded as a complete and valid verdict of a jury upon which a judgment can be rendered is an open and public verdict, given in and assented to in open court as the unanimous act of the jury and affirmed and entered of record in the presence and under the sanction of the court. So these are general statements of law that they're making, and technically, while they may be true, as I said before, the exception to every rule ever made in law is the interests of justice. Okay? Interest of justice. That's the most important thing for us to remember. The verdict which determines the rights of the parties and is admitted of record and upon which judgment is rendered is the verdict received from the lips of the foreman in court. By the way, all of these discussions about verdicts don't necessarily force the judge's hand in granting a motion to dismiss, because you don't have to have a verdict to have double jeopardy. You don't have to have a verdict to dismiss this case, right? We've seen mistrials that are because of the prosecutor or because of misconduct. So you don't ever get to a verdict, but the judge can still dismiss it. The judge can still find that double jeopardy would be violated. An appellate court could find something like that. Or, of course, the prosecutor could do the right thing and in the interest of justice say, if this jury really did unanimously find not guilty, let's not retry her on those charges. That's the elephant in the room for these prosecutors that they refuse to see, that they refuse to act on, is doing the right thing. Go ahead and retry her for manslaughter. It seems like they almost won that battle. Go ahead. And there are people that are going to be very mad at that. There are people on the internet that think no way they should be able to do that. There's not enough evidence. This jury, there were reasonable jurors on this jury that would have voted guilty for manslaughter. So it is legally appropriate. Now, I may disagree with it. If I was, czar or king of the world or had the autonomy to choose whether or not I would prosecute this case, my answer would be no. And that could be different from prosecutor to prosecutor, from lawyer to lawyer, from judge to judge. But legally speaking, there's nothing wrong with them retrying her on count 2. Is that the case for counts 1 and 3? That's the question here. It is not enough to show that the jury may have agreed on some of the issues at some time. If that limited showing were to control, uncertainties would be invited. I completely agree with that statement by the prosecutors. Can I highlight it? No. Right here. It is not enough to show that the jury may have agreed on some issues at some time. If that limited showing were to control, uncertainties would be invited. That would not be enough. I agree with the prosecutor here. Is that the facts? Are those the facts of this case? Are those the facts of this case? That some of the jury may have agreed about some issues at some time. Or did they agree on all the issues? Did they all agree? Was it a fact, not a may? And do they still agree today? Those are the questions I have that we need to get answered. No error in the judge's refusal to accept the not guilty verdict slips found in jury deliberation room after the jury was discharged, where those slips were in contradiction of the jury's report to the judge in open court that they were deadlocked. Well, see, here's what's interesting. I didn't read this case, unfortunately, but I'll give you an example of how you would differentiate this potentially. And that's what lawyers do, right? We say these cases are similar or these cases are different. That's how we argue it to a judge. So when you have a situation like this where verdict forms were found back and they may have been checked off guilty, but they came back and they were deadlocked, my question would be, was it only one count? Was it a superior charge where there were lesser includeds? How similarly or different was it than this case? Because if it was a single count DUI and they had checked not guilty and then they continued to discuss it and then they went and told the judge they were deadlocked, of course, that verdict form would not rule the day. If there were multiple counts, then it might be a lot more like this case. The hearsay comments and juror statements about what happened are legally irrelevant as the jury failed to reach any verdicts. Is that true? Is the question. All right, here's Bluford, which we've broken down in detail in the last 2 videos. The jury sent a note to the court indicating they were hopelessly deadlocked. The court asked the foreperson to disclose the jury's votes on 3 charges, which we didn't get in this case. First degree manslaughter and negligent homicide. The foreperson reported the jury unanimously agreed the defendant was not guilty of the first degree. They were deadlocked on manslaughter and had not voted on negligent homicide. Court gave the jury an Allen charge. That emphasized the importance of reaching a verdict and instructed the jury to continue deliberations. After a half hour, the jury reported that they had not reached a verdict and a mistrial was declared. The United States Supreme Court rebuffed the defendant's claim that the jury acquitted him of murder, as the foreperson reported was not a final verdict because the jury had continued to deliberate and, more importantly, gave no indication that they were still unanimous on the first degree charge. So they gave no indication at any point in the trial or afterwards. Let's not forget that. They gave, and I respect the Commonwealth here for putting this statement in because they could have just left it out. They gave no indication that they were still unanimous on the first degree charge, which is exactly why, in my opinion, we need to have a juror interview. We need to try to get these jurors in, at least as many of them as we can, to get to the bottom of when they sent the final note, were they still unanimous on the second degree charge in Karen Reed's case? Because if they were still unanimous at the end of the day, they are no longer not giving an indication. That's a double negative, but you get what I'm saying. In this case, they gave no indication that they were still unanimous. If they would have, then it could be a different outcome. The if-then proposition here. If they're still unanimous, then it would make a difference. But they weren't in that case, so it wasn't. Are they in Karen Reed's case? That's the big question that the judge, in my opinion, has to get the answer to. If we have the opportunity to get the answer and the jurors are coming forward, let's get the answer. The United States Supreme Court emphasized that when jurors engage in discussions about the circumstances of a crime, it often causes one to rethink their stance on a greater offense and revisit a prior vote. Fine, sure, that can be true. The very object of the jury system, after all, is to secure unanimity by a comparison of views and by arguments amongst the jurors themselves. A single juror's change of mind is all it takes to require the jury to reconsider a greater offense. A Tui-Rodriguez instruction is designed to urge the jury to reach a verdict by giving more serious consideration to opposing points of view. Again, I 100% agree with all this. And if a juror comes in and says, no, at first I was going to vote not guilty on that, but now I would change my mind, or at the time I would have changed my mind. As we considered it further, I flipped my vote. I would have actually been a guilty vote on second degree. Well, then the defense might lose. The defense probably should lose if that's the case. If a juror says it would not have been unanimous at the time that we actually were deadlocked and declared a mistrial, then I think the defense should lose. But we need to figure out what that answer is. Glitter Beauty said, right, it's not enough, which is why they need to hear the jury and get more evidence, which is exactly what the evidence asked for. Sassanak, question, if this was outright untrue, wouldn't you expect the juror to come out and say, no, we weren't unanimous on 1 and 3? Maybe, or the jurors that aren't coming out don't want to come out. They're too scared of maybe somebody figuring out who they are, if they have to have go and testify. Maybe they're scared of repercussions. I would guess the jurors that aren't coming out don't want to come out. I could be wrong. I've heard rumblings there are more jurors coming out. So we'll see. Tiffany said the Commonwealth is trash. I live here. All right, let's keep reading. It must be recognized as a practical matter that jury votes on included offenses may be the result of a temporary compromise in an effort to reach unanimity. That very well could be true. It could be true. A jury should not be precluded from reconsidering a previous vote on any issue, and the weight of final adjudication should not be given to any jury action that is not returned in a final verdict. Unless they wanted to, didn't think they could, and weren't provided an avenue to do so, right? I think that matters. Oral affirmation of guilt or acquittal in open court is the only evidence the court can receive of the free and unanimous assent of the jury to the verdict. Well, let's get them in open court and see if they agree. Just a thought. The jury's notes were unambiguous that the jurors were deeply divided by fundamental differences in our opinions and state of mind that resulted in a starkly divided jury as to the charges, emphasis on plural. So I like, that's very lawyerly of him to pull charges and show that it's plural. And what we're hearing now is there was only one that was not decided. But I don't know why he's even quoting the juror notes. If his argument is there's no verdict unless it's read in open court, there's no verdict unless it's orally affirmed in open court, then why even say what the jurors said? Why are their notes so important? And if their notes are so important, which gives us evidence and factually what was happening in that room and when, why wouldn't their testimony now be equally as important? The jury consistently indicated that their impasse was not due to a lack of understanding of the law or the charges, but a profound divergence in deeply held convictions, ultimately leading to a point where consensus is unattainable. The jurors' notes did not indicate agreement or acquittal on any of the charges. Rather, it was evident that the jury was unable to agree on any charges due to their sincere adherence to their individual principles and moral convictions. Contrary to the representations made in the defendant's motion and supporting affidavits, the defendant advocated for and consented to a mistrial, as she had adequate opportunity to object and instead remained silent, which removes any double jeopardy bar to retrial. Consent to a mistrial may be inferred from silence where a defendant had the opportunity to object and failed to do so. No surprise there making that argument. A lot of appellate courts have made similar decisions that if you don't object, you waive. Your opportunity is inferred if you remain silent, things like that. Where defense counsel told the judge he believed the jury was at an impasse in deliberations and had no objection to the judge declaring a mistrial, such consent removed any double jeopardy bar to retrial. Despite having an adequate opportunity to object, defense counsel remained silent, proper to infer from counsel's conduct that the defendant consented to a mistrial. The manifest necessity test has no application in situations where, as here, the defendant requested or effectively consented to a mistrial. And I think there's a good argument that they did. But if that's the case, and we're going to take their actions as doing their job, and maybe they consented to it, well, your actions as the Commonwealth, and whether or not you should do what's right and just, that should have bearing on what happens to counts 1 and 3. Christy, while that they don't want to hear from the jurors because the Commonwealth only needs one to say that that's not true, the burden is now on the defense to prove this. Wild indeed, Christy. Cooper, so according to this response, completed forms stating not guilty were left in the room. No. They were referencing, I don't know that. I don't know whether that's the case in this case or not. I don't think it is. They were referencing another case. So they're citing case law. And when we cite case law as lawyers, we sometimes give the facts that are similar and prove our point. In this case, usually it's done, as you can see here, in parentheses, or describing it like what happened in TUI was X. And that's similar to read by Y, whatever it may be. So no, they were citing facts from another case. Rebecca, you know my thoughts about your take on this. That being said, enjoy yourself at the Morgan Wallen concert. Enjoy your family time, Peter. Part of dinner on your favorite Cowboy fan. Ready for fantasy. Thank you, Rebecca. Yes. Right after this, my workday is done. I'm either going to take a nap because I was up late last night. I can't do late multiple nights in a row. I'm too old for that. Or just hit another coffee before we leave. But thank you so much. Okay. During her full opportunities to be heard on June 28th and July 1st, at no time did any of the defendant 3 counsel request any inquiry as to what charge or charges the jury was deadlocked on. That's true. Rather, the defendant was quick to request a Tui Rodriguez instruction at first opportunity. That's true. Indicating a belief based on the clear and obvious language of the jury's notes that, as stated by Yannetti, the jury was hopelessly deadlocked, had exhausted all manner of compromise, and was engaged in fundamental disagreements of what the evidence means. It's a matter of opinion. It's not a matter of understanding. And then again, citing a case, counsel's request for a Tui Rodriguez instruction permits the inference that both parties were provided an opportunity to be heard on possible alternatives to a mistrial. It's exactly what we said at the time. The timing of a Tui Rodriguez charge is committed to the discretion of the trial judge. Once a Tui Rodriguez instruction is given, the jury could not be sent out again to continue deliberations without their consent. Furthermore, following the discharge of the jury, the court engaged the Commonwealth and defendant in discussions about choosing a status date for scheduling a retrial. At no time during that hearing did the defendant object or indicate displeasure with the mistrial. Again, all pretty good points. The mistrial was also supported by a manifest necessity jury deadlock. Citing this Bryan case, in consideration whether to declare a mistrial over defendant's objection, the court must give counsel a full opportunity to be heard and careful consideration to alternatives to a mistrial. A frequent and traditional example of manifest necessity to declare a mistrial is where the jury were discharged because they were unable to come to an agreement. Mistrial warranted where the jury reported inability to reach a decision after 4.5 hours of deliberation, during which the jury twice sent messages to the judge about impasse, and the judge inquired about a jury's ability to reach an agreement. Describing hung jury as prototypical example of manifest necessity, mistrial warranted where the jury deadlocked on a 4th day of deliberation after the judge inquired about ability to reach a verdict. The trial judge is best situated to determine whether the ends of substantial justice cannot be attained without discontinuing the trial. In declaring a mistrial, premised upon the trial judge's belief that the jury is unable to reach a verdict, that decision is treated with great deference because otherwise there would be danger that the judge would employ coercive means to break the apparent deadlock. Deadlock juries are particularly susceptible to coercion. The term manifest necessity is another way of saying that in a particular case, the right of the defendant must yield to that of the public. The trial judge interacts directly with jurors and is in the best position to determine whether a jury is deadlocked. So I agree with all that. That's kind of simple legal discussion. That's black letter law. The court engaged in considerable efforts and sent the jury back to deliberate 2 times following notes that they were at an impasse. And in addition to finding that the jury had engaged in due and thorough deliberations and providing the Tui Rodriguez instruction at the request of the defendant and to her satisfaction, during deliberations, the court amended the verdict slips to depict clearly the lesser included offenses and provided the jury a supplemental instruction on how to consider lesser included offenses. And the United States Supreme Court has never required a trial court before declaring a mistrial because of a hung jury to consider any particular means of breaking the impasse, let alone consider giving the jury new options for a verdict. Yeah, you don't want to coerce or entice the jury to do something that they don't feel comfortable doing. No doubt about that. So confused if they agreed on not guilty on 1 and 3, why not say? So according to them and the reports that we have right now, they didn't know they could. They weren't given a mechanism to, but I think it's a great question, Belinda. And I think we'd be able to parse out if it's true or not, or exactly what was going through their heads at the time if we had an evidentiary hearing and got some more information from the jury, even if it's a simple 1 or 2 questions from each of them. Sonny from the H said free Charlie Adelson. Okay, it's random. The defendant's claim that the judge should have inquired of the jury holds no merit, as nothing in our case law or in these rules require a judge to make either inquiry whether there was reasonable probability of any unanimous verdicts or if the jury would consent to further deliberations. As a matter of course, and the circumstances of the judge did not necessitate either inquiry. The final note from the foreperson unequivocally stated that the jury were unable to come to a unanimous decision. In other words, that the jury was deadlocked. The note did not suggest, for example, that the jury were merely having trouble making a decision or needed further instruction from the judge. Given the 4 days of deliberations, the jury's indication that they had carefully reviewed all the evidence and that their divergent opinions were promised upon deeply held moral convictions, the court was left with no reasonable alternative other than to declare a mistrial. Further, consultation with counsel would not have produced any fruitful alternatives, nor was there a reasonable probability the jury would have consented to deliberate further, particularly when the jury wrote, to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. So one argument that I didn't really think about before that they're making here is based on the language in the jury vote, we could have considered that the jury was not going to consent to being sent back. So if they weren't going to consent to being sent back, then there wouldn't have been another opportunity to continue deliberations. Okay? I see people saying the Morgan Wallen concert is canceled. Hopefully you guys are just messing with me. But people are saying cancel due to tropical storm. Oh boy, that would suck. My wife and her friends have been looking forward to this for like a literal year. I just texted her. Oh boy, not going to be a lot of happy people. Okay. But the show must go on. All right. Moreover, whether counsel initiates contact with a discharged juror by first sending notice to the opposing party with the substance of the proposed communication, or if the juror indicates contact with counsel as alleged in the defendant's motion, counsel may communicate with jurors only about permissible subjects. Permissible subjects include counsel's performance during the trial, extraneous influence on the jury's deliberation, or a juror's bias toward the defendant. Neither extraneous influence nor a claim of juror bias is alleged by the defendant to have been an issue. Even in circumstances where juror testimony is needed to ascertain whether there was racial or ethnic bias or extrajudicial influence, a judge may not inquire into the jury's subjective thought process, content of deliberations, or reasons for concluding guilt or acquittal. Rather, the defendant's motion is entirely premised upon, and what is expressly prohibited, inquiry is that of the jury's deliberative processes and the substance of the jury's deliberations. The secrecy of jury deliberations has served as a bedrock of our judicial system, and inquiry into the jury's deliberative process would intrude improperly into the jury's function. So here becomes one of the questions of law and fact that the judge is going to have to determine. Okay? So number one, is this entering the deliberative process of the jury? Would these questions intrude improperly into the jury's function? Or are you just asking them what their verdict was? Not how you got there, not why you got there, not why you disagreed with somebody else, not the arguments you had to get there, but just a simple couple questions. Was this your vote? Did you still feel that way when you wrote the note that you were deadlocked on count 2? The lawyers will come up with something, but I'm not so sure this enters into their deliberative process or improperly intrudes on the jury's function. The common law principle that it is essential to the freedom and independence of jury deliberations is that their discussions in the jury room should be kept secret and inviolable, was not and arguably could not be overruled. It is improper for counsel to inquire with jurors or through intermediaries the individual or collective thought process of the jury, the reasons for their decision, or the substance of their deliberations. Massachusetts continues to adhere to common law principles barring inquiry into the contents of jury deliberations and any impeachment of jury verdicts based on information gained from such inappropriate inquiry. Again, the why and how, they shouldn't ask. If the jury volunteers that information, it is what it is. But I think there's a way to ask these questions without violating this. I'm going to have to text into the group just to stir things up. Give me 1 second. All right. I said I'm hearing the concert's canceled in my group chat. We'll see what they say. All right. Similarly, it would be improper for the court to inquire through affidavits or other evidentiary hearing the substance of the jury's deliberations. See, I think that, I don't know. I don't know if that would be, I don't know. What do you guys think? This is the question that Bev's going to have to answer. If after communicating with a juror, an attorney wishes to secure an affidavit from the juror, any such affidavit must focus on extraneous influences and not the substance of the jury deliberation or the individual or collective thought processes of the juror or the jury as a whole. The trial judge acted within discretion to declare a mistrial where proposed inquiry of deliberating jurors could not be made without inquiring into the deliberative processes of the jury. But they're not defining the result and whether or not they still have a not guilty verdict as the deliberative process. I would like them to show me some case law that said that if I was the judge. They asked, where did I hear that? I said, the chat. The chat, you know. The Supreme Judicial Court has instructed that whenever a judge asks individual jurors about the possibility of extraneous influences on jury deliberations, whether of those jurors or who are still sitting as jurors as such, or jurors who have been discharged, the purpose of the individual voir dire is not to delve into the jury deliberations. There should not be inquiry into a juror's individual or jury's collective thought process. Again, I think that's different. An outside influence. How did they influence how was their decision process made? What is influencing it, and why did they do it? To me is very different. Very different. All right. Christy Allison says, is it weird that not a single juror has made public comment yet since this trial has been so publicized? It's a little weird. I mean, I don't know. It's actually weirder when jurors come forward. But anybody that's following this stuff, my guess is they've got to, people are confirming. People are confirming. The group chat is confirming that the chat you know is correct. It's unfortunate. It really sucks. It does suck. I was looking forward to it, but I mean, I'm not a big concert guy. I like Morgan Wallen's fine, but I don't love Morgan Wallen. If it was like Surfaces or something like that, then maybe I'd be more excited. I don't even know where I was. Okay. Likewise, polling the jury on the various possible verdicts during their deliberations or after their discharge would constitute an unwarranted and unwise intrusion into the province of the jury, and the Supreme Court has cautioned strongly against the risk of coercion inherent in questioning jurors, particularly in individual colloquies. So again, all this case law we're reading, never does it say you can't ask them what their verdict was. How they got there, what influences they had on them, things like that. I can understand how that's entering uncharted waters. All right. One cannot assume from the mere report of deadlock that there is any final verdict lurking within that deadlock that may be extracted. In many instances, asking a deadlocked jury about partial verdicts would constitute attempting to extract from the jury something that does not exist. Yeah, but if it does exist and they tell you, that's good. If it doesn't exist, really is a deadlocked jury going to be afraid to tell you that they don't have a verdict? It's like kind of what they're already telling you. Asking a jury to report where they stand on the offense as charged invites a report that may be based on only preliminary tentative deliberations, if any, on that level of offense. But the problem is we have record evidence now at this point in these affidavits and statement directly by jurors that there is no gray area. We absolutely are in a situation, in a position to say 12-0, no doubt, and that's where we were when we left. So that's why I said it needed to be not wishy-washy, right? And that's why I pointed out the really important parts of the affidavit that were not wishy-washy creates the situation we have now. Tentative deliberation on that level of offense or hasty resumption of deliberations concerning that level of offense in an effort to satisfy the judge's apparent desire for a decision. Such inquiries of the jury may succeed in extracting a partial verdict, but we could not have confidence that that partial verdict was the product of a thoughtful and thorough deliberation process. The risks of juror coercion are too high, and the reliability of any such partial verdict returned is too low to warrant such an approach to salvaging some partial result from a deadlocked jury. I just don't know if that's what we have here. That is the big question. So let me read you guys Morgan Wallen's tweet. I hate to reschedule shows, but I powered through being sick. This dude loses his voice too much. Coming from a guy who loses his voice a lot, but we power through. And unfortunately woke up feeling way worse today. I would not give you guys anywhere near 100% tonight. And as a result, I need to move tonight's Tampa show to October 4th. Next week's Charlotte show to October 18th and 19th. Boo. Even less of a Morgan Wallen guy now. All right, let's keep reading. Sorry for all the interruptions. I'm sure it's annoying to some of you. Similarly, even if the deadlock does pertain to some distinction between the various levels of offense, a judge has no way of knowing whether the jury have in fact have they fully considered the offense as charged. A desire to extract information from a deadlocked jury does not solve the significant problem in attempting to do so. A court's inquiry into possible verdicts improperly intrudes on the jury's function, and the ostensible benefits to be gained by such a procedure are outweighed by its risk. I want to know how many criminal defense attorneys are going to try to push for some type of instruction in the jury instructions. Dude, you guys are literally the best. You guys are literally the best, the chat. You literally broke the news. Nobody knew in my group chat, which is kind of awesome because they're all pumped and I feel bad. They're all like getting stuff. We got like a party bus that was going to drive us down there. We were going to go to dinner at a nice restaurant, a whole thing planned. We'll still go to dinner somewhere as Velo recommended. So thank you for that. Thank you for that. But in this situation, when we have jurors coming forward and stating this stuff, will criminal defense attorneys now put something in the jury instructions that say you can come to a verdict on one but not all charges, still turn that in? Now, the problem is, if we do that, the lawyers are going to argue this back and forth, okay? If we do that, is that going to invite jurors to give verdicts on some counts but not others? Because we would hate that. Because whether we got to try a case again under a similar factual scenario with one charge or three charges, it doesn't really cut it down that much. So we always say, and we always push, and we always want a jury to come to a unanimous verdict on all charges, okay? That's what we want. But is there a way to create a situation where we can draw up language that makes this better and solves this problem? That is the question for lawyers to figure out. That's what lawyers do. We write rules, we write instructions, we write statutes, we try cases, we explain things to clients, we explain things to jurors, we explain things to judges. That'll be interesting. Lorraine, can you imagine giving 10 weeks of your time and your deliberation is completely ignored? I feel bad for those jurors. What a waste of their time. It's a tough situation because, yeah, I mean, that definitely would suck, but it's a tough situation. I did think you guys were messing with me. I thought you were saying it's canceled. Let's do Baldwin tonight. Let's hang out all night. I did think at first you were messing with me. Sarah, sadly, I think this is just a miscommunication on how to fill out the form. If they know to fill out what they had so far, they probably would have. But I'll just tell you, it's a purposeful decision by lawyers to not let juries think that they can partially fill out the forms. We do not want that. We do not want that. Bruh, if the retrial is manslaughter only, does it close the door on portions of the evidence in the first trial being used in the retrial? If so, example, I can't think of any. Maybe intent, but it just makes the job easier for the Commonwealth. They don't have to prove intent. So why would they bring in the intentional elements? I don't know. I can't think of anything off the top of my head. Maybe some of the motive stuff. Maybe some of the motive stuff, like the Aruba trip. Was it Aruba or Bermuda? I don't remember. Maybe stuff like that. I have to think about that more. That's a good question, bro, man. Thank you, Leslie. All right, let's get to the last paragraph here. For the foregoing reasons, the defendant's motion should be denied, as there was no verdict that acquits the defendant, no grounds for the court or counsel to inquire into the deliberative process of a discharge jury. They just missed the point. It's frustrating as I read it for the 100th time. I don't think they're getting into the deliberative process of the jury. The defendant consented to the mistrial, and the court properly declared a mistrial due to a deadlocked jury who was at an impasse due to their starkly divided perspectives on the evidence and their sincere adherence to the individual principles and moral convictions. As such, retrial is not barred by double jeopardy or constitutional principles, and the Commonwealth may retry the defendant on the 3 indictments and any appropriate lesser included offenses. All right. So there you have it. the Commonwealth's response. Will the jury... So Bodie said, Peter, do we know if the Commonwealth will retry it? Is it official? So here's what I'll tell you. What I get from this motion is absolutely they want to retry this case. Will something come up that makes them not want to? I don't know. But at this point, I think they absolutely want to retry this case on all 3 counts. Maybe they don't care about the last count, but they want that second-degree murder charge. If they didn't, they could at least save some kind of face, right? With everything we've been going through, all the Proctor stuff, all the Kevin Albert stuff, all the cop stuff, internal affairs investigation, suspensions with and without pay. If the Commonwealth stepped up and said, you know what, in the interest of justice, we want to do what's right. We're going to drop counts 1 and 3, but we basically won by a majority, count 2. So we're going to retry that because the victims deserve it. The community deserves justice. And a majority of those jurors agreed with us that she was guilty. It could be an opportunity for them to have a good press release to save some face. But no, this Commonwealth is not going to do that, which shouldn't come as a surprise to anybody. I think they are absolutely planning to retry this case. Amy's positive pathways. Bev told them not to make a verdict until unanimous on all charges. They thought she would ask each count. I have to be honest. The people blaming Bev for this, I understand it was she who read it, but the lawyers write and edit and give her the jury instructions. They have an opportunity to object to the jury instructions and put that on the record. I don't think they did that in this case, or I think that would have been brought up in one of the motions here. So while they were coming out of Bev's mouth, all the lawyers consented to those jury instructions. You have not heard, and I guarantee you the defense is monitoring, maybe not this YouTube channel, but the media in general, and they know that people are complaining about this and posting those clips. If they would have objected to it for this reason and Bev disregarded it, I would hope it would be in their motion to dismiss. That's my honest opinion on that instruction, which I've said a few times now. So much going on in LawTube. Thanks for the updates and enjoy your weekend. Hopefully you get some R&R. Yeah, I got to figure out. I think we're still hanging tonight with our friends. So tomorrow's probably going to be Baldwin, and holy crap, what a wild day we had. I have so many thoughts on Baldwin. That's going to be fun to discuss with you guys tomorrow. Those of you who are following the Baldwin case, please hit the like button if you haven't already on this video, and subscribe if you haven't already. If the FBI indict in Albert, will they still retry? So that's a different question. Whoops, I didn't mean to get rid of that. So that's a different question. If new stuff pops off, they may change their mind. But with what it is right now, they're full steam ahead is what it feels like to me. All right, folks. I am going to take off. I have to tell you guys, the FBI does know who actually killed John O'Keefe. The Commonwealth is wasting our tax money for what publicity? Okay. All right. That's all I got. I'm out of here. Enjoy your weekend, everybody. I'm in a great mood. Is anybody else in a great mood? If you are, let me know in the chat. Until tomorrow, a Saturday live stream. Make sure you're subscribed to the reminder bell is hit so you know when, because I don't even know when I'm going to do it yet. Depends on what we do tonight, how late I sleep. Gym usually first in the morning. But we'll talk tomorrow. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.